Good morning, sir. You're Brian Belvin?
Yes.
And this is cause number 25 DCCR 1485. Mr. Belvin, it looks like was accepted in a pretrial diversion, and we're just checking in. Mr. Nichols?
Judge, my notes from Ms. Molfino indicate that he is participating and being successful so far in JCDI,
Okay.
and that they expect that to continue, and that'll end up taking care of this case once he does complete the program.
How much longer?
She was asking for a 3-month reset, 90 days.
90 days?
Yes,
Okay.
sir.
We'll do 90 days.
It's a year program and I've been there 3 months, so 9 months.
He has 9 months left.
Okay. We'll do 90 days. And at that time, if you'll get with Ms. Molfino the week before, and if everything's going well, we could probably do a
Okay.
reset without everybody having to come down.
Appreciate
for
it.
Just let me know, but make sure that week before, talk to
Okay.
Ms. Molfino, she can check on it, and y'all just send me a message.
Okay.
All right.
Thank you, Your
Very good,
Honor.
sir.
Thank you for
Jasmine Jaquette, that door's locked, Mr. Belvin.
Your Honor.
Jasmine Jaquette. Good morning, ma'am. Are you Jasmine Jaquette?
Yes, ma'am.
And this is cause number, spit your gum out in that trash can over there.
Here. All right.
This is 26 DCCR 0240. Ms. Jaquette is charged with deadly conduct, discharging a firearm. Mr. Parker?
Your Honor, we're asking for reset. I've talked to Ms. Malfino about this, and I think there's a co-defendant.
Judge, I have the co-defendants in this case, and it's going to end up I'm going to have this one reassigned to me. And so I would ask for a reset also, just so Mr. Parker can get with her about what her options are.
Okay, sounds good. So, Ms. Jaquette, I'm going to reset your case about 30 days or so. Stay in touch with Mr. Parker so that once he gets with Mr. Nichols, he'll know what your options are, have all of the discovery, and you can, we'll get an announcement at the next court day.
She has actually called me.
All right, good.
I like
All right.
her.
Good. We'll see you the next court day. You're free to go. Let's see, there's a sentencing, Mr. Parker, on Marie Lopez. Good morning, ma'am. Are you Marie Lopez? Speak up.
Yes.
This is cause number 24, DCCR 0886. Ms. Lopez was previously in court, entered a plea of guilty to the state jail felony offense of driving with while intoxicated with a child passenger. There was no agreement in this case. I've received the pre-sentence report. Have you both had an opportunity to review that report?
Have Your Honor.
Yes, Your Honor.
Any additions or corrections?
No, don't worry about it.
Not from the state.
So I want to start, I guess, with Ms. French on this one. This is a very typical kind of case where probation is typically the outcome. And so I guess I'm curious. Obviously, I understand and I saw the facts, and that gives me some concern. But I think there's some treatment and things like that that could be. I guess tell me, what's your position?
I would like to see Ms. Lopez get some kind of treatment. My primary concerns based on the evidence that was presented in my file and also with the PSI was that the substance that was being abused and the fact that Narcan had to be administered. That was very disturbing from the state's point of view. And if there are, we know there are programs regarding substance abuse, maybe issues with parenting, decision-making, definitely decision-making skills. There may be some kind of mental health issues or situations that she needs help with along those lines. The state is going to defer to the court on this one. But certainly we would hope to never see Ms. Lopez here again.
Ms. Lopez, I don't disagree with what Ms. French is saying. This was a very scary situation and could have turned into something really, really horrible with your children. And so what I'm going to do today, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of driving while intoxicated with a child passenger. I'm going to sentence you to a term of 2 years in the state jail prison, but I'm going to probate that. You'll be on probation for 5 years. I'm ordering you to pay a $1,000 fine and to follow all of the rules and conditions of probation. Those are several things that are kind of typical. Also, there's going to be some that are especially for this offense. One is that you will enter and successfully complete the JCDI program. That is an intensive outpatient drug rehab program. You'll be required to follow all of the rules of that program. You're also going to be required to participate in any mental health services through Spindletop. So we're not trying to set you up to fail. What I want you to have is all of the tools necessary to be able to be successful. So if you're going to do a substance abuse assessment as well, if there's any other specific treatment that probation or that assessor thinks is necessary, then you're going to be required to do whatever it is that they ordered or that they recommend. Do you understand?
Yes, ma'am.
If you do everything you're supposed to while you're on this probation, then for all practical purposes, your case here in court is over. You will be able to serve your sentence out on probation. The other side of that, though, is if you violate any condition of probation at all, you will be back in court and you could be facing the 2-year sentence that I've already given you. Do you understand?
Can I make a request, please?
Sure.
I mean, Miss Lopez is, I couldn't ask for her to be more cooperative with me and taking care of a case and taking this serious. She just, I mean, I'm sure the court has seen it in the PSI, but this is a wake up call to her, what she's told me. She doesn't have a significant history at all that I know of. She, after this incident, she has been required to wear a drug patch. And I get reports all the time that they're negative throughout her whole time on bond. Additionally, last week she called me freaking out because she took her kids to a water park and the patch came off. She said, what do I do? I said, call whoever installed it and tell them. And she said, I've already done that. I said, well, you ought to be fine then. So she went and got it replaced. She has got her associate's degree. She's got a job. She's trying to better herself even further, trying to become a physical therapist. And she's already taken a parenting class. I'm just wishing she could get deferred because I'm worried about the conviction.
I don't think
That's right. You're right. You're right, Judge. You're correct. You can't.
Yeah, I wouldn't disagree
I
with any of that.
I wouldn't think of that. You're right.
Yeah, unfortunately, that is, there is a new on the misdemeanors where they can on some, but I don't
Right.
think I can.
You're right. We had this before.
Okay. All right. So I'm going to hand you the trial court certification. It shows this was not an agreement. There's some rights to appeal. You can talk to Mr. Parker about that. If you'll just have a seat here in the courtroom. What? Yes, ma'am.
Firearm admonition. This is an adjudicated.
Oh, thank you. Also, I'm going to hand you a written admonition regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. So if you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right. So just have a seat in the courtroom. Probation is going to call you to her desk when she's ready to go over your paperwork. So just watch for her to call your name. Good luck to you, ma'am. Thank you, Mr. Parker. Thank you, Ms. French. Jorge Quezada to sentencing.
I haven't seen him yet this morning.
Jorge Quezada.
He's coming from the valley.
His bond will be forfeited for non-appearance and reset at 100,000. And if you get in touch with him and he's on his way, just let me know.
I'll check. I've got calling her.
Calvin Smith to sentencing 2 cases. Good morning. Are you Calvin Smith?
Yes, ma'am.
And Mr. Smith was previously in court in cause numbers 25 DCCR 1638 and 1639, entered pleas of guilty to those offenses. And I've received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, sir.
Yes, sir.
Any additions or corrections?
Not from the state.
All right, Mr. Smith, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. Find sufficient evidence in each case to find you guilty. And cause number 25 DCCR 1638, defer all proceedings and place you on probation for 5 years. Order that you pay the $1,000 fine and follow all of the rules and conditions of probation. And cause number 25 DCCR 1639, also, defer all proceedings and place you on probation for 5 years. You're ordered to pay a $1,000 fine in that case also, and to follow all of the rules and conditions of probation. If you do everything that you're supposed to while you're on this probation, this is an excellent opportunity because you don't have a felony conviction on your record. And at the end of the probation, the cases will actually be dismissed and you'll never have the felony conviction. The other side of that is if you violate any condition of probation, then you can be brought back into court, found guilty of the offense, and sent to the state jail prison in one case for up to 2 years, and sent to prison in the other for between 2 years and up to 10 years. Do you understand? And I know there were some issues based on this offense and when you had your wreck, and I know your mom's helping you. You need to make sure and follow all of the rules. If you need help, if you're having trouble understanding and things like that because of the injury, then you just need to make sure, have her come with you, talk to probation so that you know everything you're supposed to be doing so you don't not do something you're supposed to. Does that make sense? All right, I'm handing you in each of your cases the trial court certifications. This shows that these were agreements that I followed, so you did waive your right to appeal. You need to have a seat in the courtroom. Probation's going to call you up to her desk when she's ready to go over your paperwork. So just listen for her to call your name, okay? Good luck to you, sir.
Okay.
And then you've got Regina Williams. You can hold that. This was the last.
It's a rejection.
Do you have anything, Anna? Good morning. Are you Regina Williams?
Yes, ma'am.
And let's see. Give me just a second to get this close. Did I just do one rejection?
Oh, I only did one. I did, Judge.
Is it the same
Yes.
to run concurrently?
Yes.
The objection may fill in that in.
No, Judge. Sorry.
Ms. Williams, in cause number 26, DCCR 0218, you're charged with a state felony offense of theft of property with previous convictions. That's from November 25th of 2025. Your indictment alleges you were previously convicted of theft May 12th of 92, and then 3 cases, January 11th of 1994, again, October 9th of 2006, April 13th of 2011, May 2nd of 2012, October 6th of 2014. And then your indictment further alleges that you were convicted of forgery, a 3rd-degree felony, August 4th of 1995, 2 cases on that day of forgery, and then another of securing execution of a document by deception. And then after those were final, you were convicted of possession of a controlled substance, a 3rd-degree felony, December 18th of 2017. Well, what that means is that if you go to trial and you're found guilty and all of those prior, or at least some of those prior convictions are true, you would be facing punishment as a 2nd-degree felony, which is between 2 years and up to 20 years. Do you understand?
Yes.
And I have here, and that's in both of your cases. The second case is 25 DCCR 1430. It charges theft of property with previous convictions, and that one's from August 9th of 2025. Again, with those same prior convictions listed and the same possible punishment range. You understand that as well.
Yes, ma'am.
And then I have a plea bargain rejection that you've signed with Mr. Parker that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty to proceed on count 1 only for an 18-month state jail term in each of those cases that would run concurrently, which means together at the same time. You have every right to reject that offer and have your cases set for trial. I want to make sure you understand that before we go to trial, what your options are and what the possible consequences are if you go to trial. And do you understand all of that? And you want to reject that offer and have your case set for trial. Have both cases set for trial. Okay. I do want to also make sure you understand that after today, I will not accept this plea agreement. This plea agreement is already extremely low for the criminal history. Even though some of it's very old, it is significant. And so and it's fine. If you're not guilty of both of these offenses, then that's what a jury's for. So I'm not trying to talk you anything. I'm just trying to tell you that I'm not going to accept this plea agreement after today. Do you understand? Okay.
Just for the court's awareness, that one reason it's been reset is there's supposedly people are going to sign a non-prosecution affidavit. Well, affidavits that she's not the one that did it, and she's got it signed, but it's not notarized. And I told they need to go to the DA's office. So that's the only.
And
Thank
y'all
you.
haven't had anybody come to
No.
do that.
Move it, Judge.
I don't think so. This is not my case.
I cannot hear you.
This is not my case. It's the small fingers.
Okay.
That one's really.
But she has not, no, nobody has been there. Yeah.
Hold on. Williams, if I test you this morning, will you have anything in your system?
No.
Have a seat in the jury box. We're going to double test that before I reset it for trial.
I'm gonna go check in.
Okay. Mr. Rojas? Mr. Samuel? Mr. Wasserstein?
On the way up. He understands what's going on. Judge, I have my assistant and help to translate. We're going to reject the offer today.
Okay, you need to do that in writing. There's a plea bargain rejection on the tablet, and then I'll call it up, and by the time she can be up here and help me go through that and make sure he understands all of that.
Yes,
Okay,
Your Honor.
I'll hold it.
Go ahead and do it.
All right,
I'm
thank
sorry we had a little emergency in the parking lot with a different county and a Zoom.
Okay.
So
That's okay, no problem. Yeah, no
we'll
problem.
get it done, Judge.
Sure.
Thank you.
And they can, if you need some help, I'm sure one of the attorneys can.
I probably will.
Okay. Mr. Burbank, you've got Tiona Hughes. I'm sorry.
Thank you.
I'll hold it. What about Crystal Robertson, Mr. Burbank? I'll hold it. Ms. Simmons, are you handling Austin Tebow?
Yes, Judge.
2060 CCR 1102 on Austin Tebow. Good morning. Good morning again. Good morning, sir. Are you Austin Tebow? And this is cause number 26, DCCR 1102. Mr. Tebow is charged with publishing or threatening to publish intimate visual material. And what is the announcement?
Yes, Judge. I believe this is Mr. Gallagher's first setting. We're just asking for a reset to work the discovery.
All right, any issues? I'll just do a normal reset, Mr. Tebow. That's about 30 days or so. Make sure you get in touch with and visit with your attorneys before the next court date so you can go over all of the discovery that they've received, and we'll see if we can get an announcement. All right, you're free to go. Thank you. Mr. Kimler, you've got Charles Beard. Okay, here with us. Yeah. So should we just bring him over tomorrow? Or do I do at large, I guess, on this case?
I think it's a new case.
I didn't check what it was.
I'm not sure.
Can you tell when you look at it? What? Okay. This is Miss Malfino's case on Charles Beard.
I think his mother's here.
Hmm.
His mother is here.
We just need to see why he's in our he's in jail. So we need to, I'll just need. It does say parole violation, not a new case. You don't have, do you have any notes or from Ms. Malfino that shows any new case?
There is an evading and a theft from September that appear to be pending. He is on parole through 2036. So
Those are misdemeanors that are already pending.
it doesn't say here on it.
Can you tell if he also has misdemeanors? Oh, so there's a new case as well. Burglary of a habitation from June 25th
We don't have that yet.
and June 23rd for burglary of a building. And March 1st for possession, all while on bond for this case. So I'm going to find that he is at large without proper bond in this case and reset the bond at $100,000 in this case. All right. Evelyn Odom, the sentencing.
She's fine.
Judge, we had agreed on a misdemeanor reduction for her to do 30 days. Today's just her, especially turn herself in. There's no
Got it. Good morning, ma'am. You are Evelyn Odom. And Ms. Odom was previously here in cause number 26 DCCR 0403, entered a plea of guilty to a lesser offense of Class A misdemeanor evading arrest or detention. And I reset it for sentencing. Ms. Odom, have you been arrested for anything between when you were here to plea and today? All right, then any reason not to go forward?
No, Your Honor.
All right, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of the Class A misdemeanor of evading arrest or detention. Sentence you in accordance with your agreement to a term of 30 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody previously on this case that the law gives you the right to receive. I'm handing you the trial court certification that shows that this was an agreement that I followed, so you have waived your right to appeal. All right, good luck to you, ma'am. You can go back with the bailiff.
During a routine status hearing, the defense updates the judge on Mr. Nichols' progress, explaining that he is currently participating in the JCDI program and is expected to remain in treatment until completion. Based on his ongoing participation, the defense requests a 3-month continuance to allow him enough time to finish the program. The judge agrees to the request, grants the 3-month reset, and notes that future status updates may be handled through a simple court reset without requiring everyone to appear in person, helping streamline the process.